Hello दोस्तों, good evening. Today we will going to discuss union territories under the Indian Constitution. Friends, you know that union territories are federal territories and are administered by the Union Government of India. They are also known as centrally administered territories. In the union territories, lieutenant governors appointed by the President of India. The Lieutenant Governors serve as a Union Territory administrators. If we go back to the history of India, we have know that the Union Territories were introduced in the State Reorganization Act 1956. The concept of Union Territory was added by the Constitution 7th Amendment Act 1956. Guys, you know that why need of Union Territory? Why need for the Union Territory? What are the needs for the Union Territories? The varying reasons for the formation of the Union Territory included such territories being too small to be independent or too different economically, culturally, and geographically to be merged with the surrounding states, or are financially weak or politically unstable. So, due to the aforementioned reasons, they could not survive as a separate administrative units and needed to be administered by the union government. Some were made union territory given their location or the special status. The union territories of Daman and Diu was under the rule of the Portuguese, while Puducherry was governed by the French. They have a different culture than their surrounding states, and the special provisions may be required to preserve this identity as well as to provide effective governance. Lakshadweep and Andaman and Nicobar Islands are located far from the mainland of India and occupy the strategic location. Union government central on them may be considered as necessity from the national security point of view. Guys, another part is Delhi. Delhi is the administrative capital of India, while Chandigarh is the administrative capital of both Haryana and Punjab. This special place that the Delhi occupies in India's polity due to its begin the capital begin begin this special place that the Delhi occupies in India's polity due to it being the capital of the country, necessitates union government control on it. So guys, you know that in 1956 we had 14 states and 6 union territories. Over the years, the number of states increased to 28 and the number of union territories increased to 8. तो हिमाचल प्रदेश, मणिपुर, त्रिपुरा, सिक्किम, गोवा, Arunachal Pradesh, and Mizoram are the some union territories that became the full state since the 1960. So, Union Territories of India. India currently has 8 union territories: Delhi, Andaman, Nicobar, Chandigarh, Dadra and Nagar Haveli, and Daman and Diu, Jammu and Kashmir, Ladakh, Lakshadweep, and Pondicherry. In 2009, Jammu Kashmir Reorganization Act 2019 was passed by the Indian Parliament, and it reconstituted the state Jammu and Kashmir into the Union Territories. Union Territory of Jammu and Kashmir and Union Territory of Ladakh. In the 2020, Dadra and Nagar Haveli and Daman and Diu were merged into a single union territory known as Dadra Nagar Haveli and Daman and Diu. And guys, you know that constitutional provision related to the union territories. So when we talk about the constitutional provisions, there are the several articles speaks about the union territories. So Article 239 to 241 in Part 8 of the Indian Constitution deal with the matter of union territories, and there is no uniformity in their administrative system. because the original constitution under Article 239 provided for the administration of union territory directly by the president through the administrators. So Article 239A was brought in 1962 to enable Parliament to create legislatures for the Union Territory. In this direction, some of the Union Territories were provided with a legislature and a Council of Ministers to fulfill the democratic aspiration of the people of these territories. Article 239AA of the Indian Constitution was added by the Constitution 69th Amendment Act 1991 according to the special provision for the National Capital Territory of Delhi. Under Article 240, President has the power to make regulation for the peace, progress, and good governance of Andaman and Nicobar Island, so that Lakshadweep, Dadra, Nagar Haveli, Daman and Diu, and Puducherry. In this case, the Puducherry, the President can make a regulation to legislate only when the Assembly was suspended or dissolved. A regulation made by the President has the same force and effect as an Parliament. Article 241 of the Indian Constitution states that Parliament may by law constitute a High Court for a Union Territory or declare any court in any territory to be a High Court for all or any of the purpose of the Constitution or National Capital Territory as a separate High Court. So dear friends, we know that only National Capital Territory of Delhi has a separate High Court, but others have no High Court. When we talk about the constitutional status of the NCT Delhi or other Union Territories, the center has power to administer the Union Territories through the administrators. The Union Territories, except Puducherry and Delhi, do not have any legislature of their own. Thus, the power make laws on any of the subject under all lists mentioned in the 7th schedule resides with the Parliament. This power also covers the Puducherry and Delhi. The Minister of Home Affairs at the center is the nodal ministry for all matters related to the Union Territories relating to legislation, finance, budget, service and appointment of administrator. So guys, what are the difference between state and union territory? In this section, we can understand the difference between a state and the union territory in India. While India, state enjoy a federal relationship with the union government with the division of legislative, executive and judicial powers. In the case of union territory, it is more of a unitary relationship with the union government as well as legislative and executive powers reside with the government of India. A state is a constituent division and has its own elected government that has the power to frame the laws, while a union territory is a small administrative unit and is ruled by the union government except for Delhi, Jammu and Kashmir and Puducherry. A governor is the constitutional head of the state, while the President of India is the executive head of the union territory. Also, the administrator position is quite distinct from the position of a governor of a state. He does not have the discretion accorded to the governor, whose is an independent position under the constitution. The administrator is an agent of the central government. The chief minister, elected by the people, administers the state, while the union territory is administered by the administrator or lieutenant governor appointed by the President of India. You know guys, the states enjoy the autonomous powers while the union territories do not have any autonomous powers. When we talk about difference between union territory, the union territory of Andaman and Nicobar, Chandigarh, Dadra, Nagar Haveli and Daman and Diu, Ladakh and Lakshadweep do not have any legislature, while Union Territories of Delhi, Jammu and Kashmir, and Puducherry do have elected legislature and government. The Legislative Assembly of the Union Territory of Puducherry may make laws with respect to the matters enumerated in the list second and list third in the 7th schedule of the Constitution, insofar as these matters are applicable in relation to the Union Territory. The Legislative Assembly of the National Capital Territory of Delhi has also this power, with exception that entries 1 to 18 and 18 of the list second are not within the legislative competence of the Legislative Assembly. Every Union Territory is administered by the President acting through an administrator appointed by him, and it is of the President to specify the designation of the administrator. It may be Lieutenant Governor or Chief Commissioner or Administrator. In India, 5 Union Territories, namely Delhi, Puducherry, Ladakh, Jammu and Kashmir, and Andaman and Nicobar Islands, are governed by the Lieutenant Governor, while the rest 3 Union Territories are governed by an administrator. Friends, now we are going to talk about undermining the democratic rights of the people living in the Union Territories. The citizens living in the Union Territories have no resource to hold the people governing them accountable, which undermines the democratic rights of these people, which are otherwise available to people living in the states. There are 6.38 crore Indians living in 8 Union Territories of India who are denied the democratic right of having their assemblies with full powers as enjoyed by those living in the 28 states. Even in the case of Union Territory, which do have an elected government, they have very limited power as compared to the states. The Union Territories are often at the mercy of the appointees of the central government. The constitutional experts are saying that out of the recent example of the protest in Lakshadweep Island against the administrator's policy, as a case of the Union Territory administration failing to represent the interest of the citizen of the Union Territory. The original criteria for the creation of the Union Territory do not hold anymore. The population or size cannot be criteria for deciding whether people deserve a state or a Union Territory. As some erstwhile Union Territory like Mizoram, Arunachal Pradesh, Sikkim, which have become state over time, continue to have a smaller population as compared to some current Union Territories like the Puducherry and Dadra and Nagar Haveli. Also, the argument that these Union Territories have distinct culture and hence need to be protected does not hold in current times, as there is no great cultural separating them from the neighboring states for the smaller Union Territory like Daman and Diu or Puducherry. In fact, they continue to have cultural and linguistic ties with the neighboring states. When we talk about the structural fragility of Union Territories, the structural fragility of the Union Territories in the constitutional scheme of things makes it easier for the central government to interfere in the functioning of the Union Territory as they destabilize them. Composition of the legislature. If we talk about the composition of legislature as per the constitutional provisions regarding the composition of the legislature of Union Territories, it is a body that is elected or partly nominated. A legislature that is partly elected or partly nominated cannot uphold democratic aspiration, a simple amendment in the Government of Union Territories Act 1963 can create a legislature with more than 50% nominated members. A predominantly nominated house cannot promote the representative of democracy. Then come to the point issue of nomination. The process of nominations is prone to the politicization as observed in the case of Puducherry. The union government had nominated members to the assembly without consulting the government, and this was challenged in the court. Unlike the provision for the nomination of the members to the Rajya Sabha under the Article 80, which specifies the fields from which members will be nominated, in the case of nomination to the Puducherry Assembly, no such qualification is laid down either in the Article 239A or the Government of Union Territories Act. This leaves the field open for the Union government to nominate anyone irrespective of whether he or she is suitable. The Union Territory have not been granted necessary autonomy, thus depriving them of a fully democratic setup. Enormous powers have been vested in the administrator, lieutenant governor in the Union Territory. Under the Section 44 of the Government of Union Territories Act and Article 239 AA Clause 4 of the Constitution, the administrator has the right to disagree with the decision of the Council of Ministers and then refer them to the President for final decision. The administrator can then take all actions he or she deems fit in the matter in total disagreement of the elected government. This allows the Union government to control the Union Territory through the administrator and is hindrance to the idea of the free and autonomous government in the Union Territory. The President decides on the advice of the Union government, so in effect it is the Union government which finally determines the disputed issues. Despite the Supreme Court noting in the NCT of Delhi versus Union of India 2019 case that the administrator should not misuse his or her power to frustrate the functioning of the elected government in the territory and use it after all methods have failed to reconcile the difference between him or her and the Council of Ministers, there has been no improvement in this regard. In Puducherry, conflicts between the Lieutenant Governor and the Chief Minister were prenominal, and similarly in the National Capital Territory of Delhi, the tussle between the Lieutenant Governor and the CM continues. Guys, we are going to discuss some interesting facts regarding the Union Territories of India. So, NCT of Delhi is the only Union Territory having a separate High Court. The Union Territories have no separate representation in the Rajya Sabha except for Delhi, Jammu and Kashmir and Puducherry. So guys, we have learned that matters of political powers, constitutional status and several other factors from this topic.